Hi, this is Ty Hyderali. I'm a plaintiff's lawyer with offices in Montclair, New Jersey and New York, and we concentrate in the area of employment law. I want to speak to you today about a great case that came down from the Appellate Division. It was an age discrimination case against the Randolph Township Board of Education. And the employee in this case was a gentleman named Charles Kazaba Jr., who was a security guard for Randolph for approximately 20 years. And at the time he filed a lawsuit against Randolph Township, he was 67 years of age. So he'd been there about 20 years as of 2012 when he filed this lawsuit. And the case is really a great case because it talks about what the court called a roadmap of retaliation. So there are a lot of individuals who can probably relate to what happened to Mr. Kazaba, which is you file a lawsuit against your employer, you continue to work for your employer, bad things might happen after the lawsuit was filed. So the court made mention of several things which are of great import to plaintiffs' lawyers who concentrate in employment law to see if their clients went through or have gone through similar things that Mr. Kazaba went through. So the lawsuit was filed on June 23rd, 2012. Soon after the lawsuit was filed, the high school principal in September of 2012 calls Mr. Kazaba into her office, and the principal, Debbie Ioso, says to Mr. Kazaba 3 times, you know that I evaluate people's performance and I do the performance evaluations, and said it in a very threatening and retaliatory fashion where Mr. Kazaba understandably felt concerned about his job safety. And of course, this came months after he filed this lawsuit in state court. What happens next is the principal writes Mr. Kazaba a letter about 4 days later, September 10th, 2012, outlining his job duties, which she had never done before, and also saying, by the way, your work location is not in the high school. If you need something, we'll put up a football ticket shelter, which was this small little box that you can use for shelter, but you're not really welcome in the high school premises. And of course, I'm paraphrasing what was actually said to Mr. Kazaba. September 2012, the high school principal takes away certain job duties from Mr. Kazaba. October 2012, Mr. Kazaba requested for paid time for some work he did, placing messages on the outside offices. And in the years that preceded, he had always been paid for the 8 hours that he put in for this job that he did. Well, not so much in 2012. And this retaliation continues. He's given a Rice notice in April 2013 about that his employment will be discussed. In May of 2013, he's put on a corrective action plan, which had never been put on before. And of course, as I noted earlier, he had worked there for 20 years. And it continues. Another Rice notice follows in February 2014. Another concerns about his employment by his supervisors. And the court looked at all of this and they said, listen, there's not enough facts here to support a claim for age discrimination, but there certainly seems to be a roadmap of retaliation that this gentleman encountered, sufficient to sustain the jury's finding of a verdict in favor for Mr. Kazaba for age discrimination retaliation. The jury didn't find enough evidence to find for age discrimination, but they did find enough evidence for retaliation. So a great case for plaintiffs, for employees out there who face retaliation after they make complaints against their employer, and certainly a case that is a good read with regard to giving a roadmap of retaliation. This is Ty Hyderali. Be safe and be well.